Hi guys, welcome back to Battle with Ola. My name is Mujola. Thank you so much for tuning in once again. Today we want to talk about recalling a witness in an ongoing litigation. Now someone asked the question and they actually referenced criminal matter. So that's why I'm going to be using a criminal matter as the case study here. How do you recall a witness that you have already called in a criminal matter? So this is another episode of Ask Me Anything Legal on Battle with Ola. Subscriber mailed me and said that Learned Counsel Ola to recall PW1 who has testified in a criminal case in the magistrate court and cross-examined by defendants who did not have a lawyer but now has a lawyer. How is it done? So I've already written them an elaborate reply, even linking something that they could read about, and then they replied and said that the brief of the issue is that the suit is a criminal matter. The accused, the defendant, was arraigned in the magistrate court for stealing and threat to life. The defendant did not initially have a lawyer. The prosecution called PW1 and PW2, and DW1 was also called. Later on, DW1 now engaged the services of a lawyer, that is the defendant. The defendant's lawyer wants to recall PW1 and PW2. I'm guessing that DW1 is also the defendant, that is, he was called as the sole witness in this matter. And then the defendant's lawyer also wants to cross-examine prosecution witness to use extrajudicial statement of PW1 and PW2, which the prosecutor did not tender in court. So can you produce a video about battle on these issues? Yeah, I can. That's what I love doing, producing videos talking about the law. So how do we go about this? Ordinarily, if in a criminal matter, I'm using a criminal matter as a case study, but really in any matter in court, in any ongoing court matter, a party or a counsel can decide that they want to recall a witness that has already given evidence. So we're using recall and not call, because that witness has come to court before and given evidence, but now you want to call the witness back to come and give evidence again on maybe they were not asked some certain questions that you believe they need to shed some light on or bear witness or testify about, which is very crucial, fundamental to the case. So, but in any case, it's important for you to understand that recalling a witness is at the discretion of the court. So only the court can permit either party to recall a witness that has already been called in a matter. So you need to make an application to the court, to the judge. It could be oral. If it's a magistrate court, you can make an oral application. But if you are at the high court, you need to probably do an affidavit, asking the court for an order of recall, to make an order of recall. Now, you need to do this because you cannot play with the court's time. The court does nothing in vain. So you cannot just come to court unprepared, banking on the fact that you can always recall a witness. No, you have to be fully prepared at all times. And if there's a need for you to recall a witness, you have to ask the court for permission, and the court will only grant it if the court finds it justified to do so, or justifiable to do so. So you need to ask the court, telling the court why you think that it is important for that witness to be recalled by you, and the court will only grant this if the court is persuaded that not recalling that witness can occasion injustice, or it can be very prejudicial to your case. That's when the court will really allow you to recall a witness. So you can make an oral application, I've said, or you can do an affidavit, depending on the court where you find yourself. Also, the court can mandate you to do an affidavit, even if it's a magistrate court, in which case you have to now advance reasons why the court should grant your application in a written address attached to the affidavit, praying the court for an order of recall. That's how to recall a witness in a criminal matter or in any matter at all. So this person also said that the defendant's lawyer also wants to cross-examine prosecution witnesses to use extrajudicial statement of the PW1 and 2, which the prosecutor did not tender in court. So I need to clarify something. The prosecution is not bound to tender its witnesses' statements in examination, okay? So that if the defendant actually wants to use the prosecution's witnesses' statements, which would be either to establish discrepancies between the written statement and the oral evidence that the prosecution's witness has given during examination in chief, or during cross-examination to actually pick holes or discredit, the prosecution witnesses' evidence given during cross-examination, the onus is on the defendant to tender those statements through the prosecution's witness during cross-examination. So the prosecution does not have any duty to tender its witnesses' statements in a criminal trial. So it's very important to note that. So if this is the purpose for which you want to recall the witness, fine, explain it in your affidavit. Now you need to adduce reasons to show that you were not negligent or careless, rather there were supervening events. For instance, the defendant did not have a lawyer. Why did the defendant not have a lawyer, and why was the defendant, allowed to go on and represent himself in a criminal matter? I understand that it's stealing, so it's not that serious an offense. It's a serious offense, but it's not that serious. It's not a capital offense. So yes, there might be the defendant can represent himself well, but you need to now explain. Is it that he was indigent? Is it that there was no counsel ready to represent him? What really happened? Why did he not have a lawyer? And then tell the court why you want to now tender the statements through the prosecution's witness that you want to have recalled. So it's important. Just adduce your reasons to the court, and if so persuaded, the court will grant you. The court is very particular and careful with criminal matters, because injustice must not be occasioned because somebody's life is on the line. If someone goes to prison, their life never really remains the same again, especially in a correctional facility situation that we have in Nigeria. You know how it is if you're a Nigerian. So it's important for the court to ensure that justice is done, and that's why there's the constitutional safeguard of the presumption of innocence for any accused person or defendant. So once you've adduced your reasons, the court will grant it to you, and then you can now tender the prosecution's with the PW1 and 2's statements through them when they are recalled, so that you can discredit the evidence, puncture holes in it, establish discrepancies and what have you, and in support of your case. So that's how to recall witnesses. That's how to tender prosecution witnesses statements. The onus is on the person that needs it, because the prosecution does not need their own witnesses statements. Once the witness is already in court and has given evidence orally to their own satisfaction, they do not need to tender their witnesses statements. It's the defense that might need it, and it's on the defense to ensure that they actually tender it. So that's all I have for you in this video. Let me know if you have any further questions. I will always see you in my very next video. Don't forget to subscribe to those.